there is always this strange silence when you start a webinar, because we're looking at the list of the numbers of participants, which slowly goes up as people electronically file into the room and find their virtual seats. And I think we'll soon be ready to start. So welcome everybody to this joint Town Legal and 39 Essex Chambers webinar. I've been really looking forward to it. It's on judicial review and the planning system in 2021, practical tips, current trends, and what's round the corner. So before I explain how we're going to run the webinar, perhaps we'll let everyone introduce themselves, and starting with Catherine, who has her yellow hand up.
Oh, I inadvertently have my yellow hand up, which is not a good start. Hello, everybody. I'm Catherine Barnes. I'm a junior barrister at 39, and I've also been looking forward to this for a while. A lot of my practice, I suppose that is probably the case for barristers because that's what we do, but a lot of my practice is JR and High Court work. So I look forward to hearing what everybody's got to say on the subject.
Okay, Celina.
Everyone. So I'm a member of 39 Essex Chambers as well. I've been practicing for a long time as a junior. And in fact, I have seen the increase in judicial review cases from the beginning of my career in the 90s to it being a central part of what we do as planning barristers on a weekly basis, whereas before I think it was much more dominated by inquiries. But I'm looking forward to discussing everything.
Yeah, absolutely. Richard.
Thanks. I'm Richard Harwood, head of chambers at 39 Essex, and do planning, environmental and public law. May end up mentioning one or two cases I've been involved in recently when we start the session.
Hard to avoid them. Chris.
Yes, thanks, Simon. Good evening, everyone. Chris Todman, Town Legal, and I'm an associate. I actually only joined in March. My previous background is local government, most recently for Westminster and RBKC, but previously also for Guildford Borough Council. Obviously all very affluent areas, so lots of JRs. And so as a result, I've dealt with quite a few pre-action protocol and claims in my time.
Yeah, thanks. And I'm Simon Ricketts. I'm a partner at Town Legal. And yes, from my perspective, the rulings are being still handed down by the planning court at a ferocious rate. There are a number of interesting cases at various stages of the appeal process. And we're in an environment where we're facing not only potential significant changes to the planning system, but also potentially significant changes to the judicial review system. And one of the things we may look at is the way in which there are interfaces between those two. So how we're going to run the webinar today is pretty informally, with a series of short presentations from each of us. At any time, please use the Q&A button at the bottom of the screen to ask questions, and we'll try to pick those up either as we go through our presentations or at the end, and we'll try to leave plenty of time at the end for questions and a bit of discussion amongst the panel. And I'm sure you know by now how these webinars work, but by way of reassurance, you can see us, we can't see you. So, and if you lose connection, then just go back in through the same link. At the end of the session, there is going to be a recording which we'll send round. It usually comes around the following day. So if you miss anything, you can watch it all again. And so I think that's all I had to say by way of preliminary comment. And I will look first of all to Catherine to set the scene in terms of the planning court as it is now. Catherine.
Thanks, Simon. Well, I'm going to be talking about practice and procedure, and the focus of my talk is going to be the recent rule changes. And I hope that you'll see from my talk that the vast majority of them, at least, I would say, reflect good practice. So I strongly suspect that you're already doing lots of the things that are now mandated. And if we have time, which I suspect we won't, I was going to talk briefly about strategies for speeding up litigation in the planning court, and also do a little bit of revision on time limits, because that always seems to be a tricky topic. If I don't have time to talk about parts 2 and 3, you've got the slides, so you can look at them in your own time afterwards if you wish. So what has actually changed then? Well, from the 31st of May this year, the previous Part 54 practice directions have all been replaced. So we've now got 4 new ones, A, B, C and D. Part 54A is the general judicial review practice direction. And I've said there must read, and I really do stress that. This is if you're doing if you're a JR practitioner or you end up doing a claim for judicial review, you're going to need to familiarise yourself with that practice direction. B is concerned with urgent applications and applications for interim relief. C is concerned with venue, and really there's nothing particularly interesting to see there. The general principle is that you should be issuing claims in the region where the claim has greatest connection. That's the overriding principle. And then the final practice direction, planning court claims, you may be relieved to hear that there are no substantive changes there at all. So it really does just reflect a little bit of kind of reformatting, but what was there before. So as I say, your focus, if you're trying to get to speed with these changes, should be practice direction 54A. And if you now log off or fall asleep because it's so tedious, just before you do, the headline points for these changes that I hope you remember, even if you don't remember anything else, are clarity, concision and candour. I would say they are the overriding principles. So if you remember those, you're probably in a good starting place at least. So some general points first, and starting with pleadings. The focus is on clarity of pleadings and concision. And they really do go on about this. There needs to be much more rigour in terms of how pleadings are put together. So definitely something to think about. And there's also a real focus on making pleadings as focused as possible so that they assist the court and there's not getting lost in detail. And we actually have maximum page limits now, 40 pages for statement of facts and grounds, 30 for summary grounds, 40 for detailed grounds. But the practice direction stresses they are absolute maximums. So presumably that's for very complex claims. The expectation is that pleadings will be significantly shorter. And in my view, that is a good discipline anyway and represents good practice. And I often find that some of the best barristers that I'm against will produce very short pleadings. Duty of candour, very big emphasis on that throughout, and particularly, this might surprise you, a reminder that it applies to claimants just as much as defendants. And the practice direction goes so far as to remind claimants that they are obliged to make necessary inquiries before issuing proceedings. So you can't just say, oh, sorry, I wasn't aware of those facts. You need to show that you try to find out the relevant facts before you went ahead and issued your claim. And so really quite serious onerous responsibilities there on both sides that the court will take breaches of very seriously. Oral renewal hearings, my experience is that they're listed for 30 minutes anyway, but the practice direction is now clear. The standard length of an oral renewal hearing is 30 minutes to include judgment. And if you need longer than that, you need to apply in advance with an agreed time estimate. And the expectation, obviously, we've been doing everything remotely, but going forward for everything, kind of parallel process for bundles in that you need to submit hard copy, but also an electronic copy. Another important point to make concerns amendments. There is a view in the administrative court, and I think it's fair to assume that that also includes the planning court as a subset of the administrative court, that we public law practitioners have been quite lazy about formalities in litigation procedural rigour. So I referred earlier to a lack of clarity and precision in pleadings, but there's also a view that we've been a bit naughty about departing from pleaded cases without making formal applications to do so. And you can see why that is a concern, because I have to say it really annoys me when I act for defendants and interested parties when people do just depart very significantly from their pleaded case, and it's very difficult to resist, particularly if you don't want then enormous cost consequences for your clients. So the expectation going forward, if you depart from your formally pleaded case, you need to make a formal application to do so. And you need to apply Part 17 of the CPR. So that's normally the realm of civil practitioners, but we're going to need to get to grips with it and make a formal application. You need to apply promptly, explain need and any delay. And in my experience, I wonder what others think about this, but the test that seems to be applied is really the merit of the application. Would the amended claim have merit? But also then obviously looking at any prejudice to the defendant. So the sooner you do it, the less prejudice there'll be to the other side, the more time they have to think about it.
Thank you. Catherine, I can just sort of chip in. I've had a couple of applications recently, and what's notable is the court is also very much concerned about prejudice to its own procedures. So the judges aren't happy about dealing with these applications at the substantive hearing if they think that there may be a need for more evidence or it may affect the substantive hearing timetabling. So the judges do want these applications made as quickly as possible when the occasion arises, and for the parties to get them, sort of encourage the court to deal with them quickly, both on paper and when it comes to any oral hearings, rather than a sense of, well, okay, you make the application, or similarly on renewal or grounds on permission, but we can deal with it at the hearing. I think the instinctive approach of the judges is that they don't like that these days.
That's really helpful, Richard. I mean, I have to say I've done it before in the past, just sort of saying, oh, we'll deal with it at the hearing, and I have got away with it, but I really do sense that is changing now. So we all need to be very careful about it and front load it much more. A couple more slides, and then I will hand on to something more interesting. Skeletons. So again, this key message about concision and clarity, and there's a 25-page limit for skeletons, which I suspect practitioners will find more difficult, particularly because the skeletons have to be self-contained. And the practice direction is very clear. There's a risk of the court returning your skeleton if it doesn't comply, so if it's too long and the costs being disallowed. So I think for some people anyway, that will require a real approach to the way they prepare their skeletons. A few more significant changes in terms of bundles. If your bundle is over 400 pages, you are required to provide a core bundle. Solicitors have to certify that the bundle meets the requirements in the practice directions. And also 7 days before the hearing, this is the final hearing, the parties have to agree on and lodge the authorities bundle. So that's a bit earlier. Normally it's 3 days now. That's what the standard directions say. So again, more front loading. And here, this is the really new bit, an agreed list of issues, chronology, essential reading and time estimates. And you'll remember that previously that was something that was supposed to be in skeletons, whereas now it has to be done in liaison with the other side. I wonder, I haven't got any current cases where the practice direction has been in force at this stage, so I don't know what that will be like. I'd welcome others' views. I mean, in theory, it sounds really helpful, but of course, it's going to depend on who your opponent is and how cooperative they are.
Sorry, very quickly, just on that. I mean, in the past, I have experience of being required to, as a matter of direction, to agree a statement of issues in common ground and required to produce a chronology. So I think that's kind of practice that's already been in there. But rather like in planning inquiries, trying to agree, statements of agreed issues can sometimes in itself simply not occur because the way that you want to phrase your issues and present your case is fundamental to your arguments. And so I think I can see why judges want it, but it's not as simple as perhaps it's as expected. So I'm just flagging that up because in the past I've had to deal with it, and so we have not been able to agree, rather like in planning inquiries. And then when you stand there and I've stuck in issues that should have been agreed. So it's a bit of a, I don't know whether it's going to be helpful or not.
And potentially very time consuming. That's my experience of statements of common ground in inquiries, reviewing multiple drafts of them and so on. So potentially cost implications for the client, or I don't know, we'll just develop a kind of very lazy shorthand of just writing out what the headline of the ground. But anyway, we'll see whether we get away with that. The final thing I just wanted to say is about urgent applications and applications for interim relief. I've dealt with it last, and I'm not going to talk about it at any length just because it's not something that comes up too often in planning and environmental cases, but it does sometimes, and I've cited the Kia case there as an example just to sort of warn people that it can happen, which was an environmental case. So it's definitely something to be aware of. And all I will say is that the courts are really cracking down on abuse, as they see it, of the urgent applications procedure, which is effectively N463. So if you are making an urgent application or an application for interim relief, for God's sake, read Practice Direction 54B, fill out N463 with extreme care, no blanks or cross-referencing. Every box needs to be properly filled in, and really think, I mean, it's not to put people off, because in some cases it will be entirely appropriate, but just really, I honestly now, whenever I am doing a case that involves that form, I really test myself. What are the reasons for urgency? What is the irreversible harm that's going to happen to my client unless this application is granted ASAP? And it's got to go beyond just the desirability of the underlying claim itself. What's the reason for actual urgency? And the courts have now also been very clear. Urgency means within the next few days, so really up to around 7 days. If you want something dealt with within a couple of weeks, then this is not the right procedure, and you should be making a normal application and just do a covering letter saying that it needs to be dealt with by a judge within a couple of weeks. And then unfortunately, I suspect it will be for the solicitor to ring the court on a regular basis to make sure that it goes before a judge within the required timescale. I will pause there because I could take up the whole webinar talking about procedural changes. And I'll leave the remaining slides for you to look at in your free time, but that covers the recent rule changes in summary.
Thank you so much, Catherine. obviously, as a lawyer, I find that pretty scary, but I suppose when you think back to the establishment of the planning court in 2014 and the reasons for it to be established to administer justice more swiftly in planning cases, part of that is to make sure that cases are brought forward efficiently and with as little fat as possible. So, and of course, we know the individual approaches of the judges that take these principles and these rules seriously. So that's a great way to start. Now, Richard is going to speak next, and I think we're going to start to look more at potential substantive grounds of challenge that all of us are experiencing on a regular basis. But I'll pass to you, Richard.
Yeah, Simon, thank you. I'm asked to look at the sort of issues which tend to crop up, particularly in the context of judicial review. So a lot of what I'll say will be in terms of the scrutiny of local authority decision making, although with some implications for looking at ministerial and inspector decisions. So I'm going to pick up on really about half a dozen topics which tend to be where people are focusing. First of all, policy interpretation and application remains contentious. I think if you're looking at that, bear in mind the distinction between what the interpretation of policy, what it means, and the way in which it's being applied. Interpretation of policies for the court, the way in which it's applied is for the public authority, subject to general public law review, albeit that if the particular report doesn't make clear what the interpretation is, there's sometimes quite a difficult overlap as to how somebody's critiquing what the authority has done, whether it's the interpretation which leads to how they come to that result, or it's simply the way in which they've applied it. The courts, having said it's for them to look at taking a bit of a broader view, and there's almost sometimes slightly more generous view on interpretation. So I think some recent cases to look at, the Supreme Court decisions in Hopkins Holmes a few years ago and in Sam Smith, both cases really where Lord Faulks was saying essentially let planners be planners and don't make the policy interpretation overcomplicated. But it all needs to be looked in sense. I mean, read it in context and try and see what it's trying to say. Second issue is a whole series of cases looking at the adequacy of reports to council members. So what goes in the committee report. And I think where the courts have been most concerned is where important representations, particularly important internal advice, hasn't been properly reported. So there's a string of cases. The Liverpool Open Society judgment in the Court of Appeal last year was a situation where the conservation officer's response, the fact the conservation officer objected, wasn't actually reported. So some of the conservation officer comments had made it into the planning officer analysis, but members wouldn't have been aware there's a conservation objection from within their own authority. And in the decision in Kinsey a few weeks ago, the conservation officer advice did make it in the most part, but the fact that she objected wasn't mentioned. And where the officer had identified levels of harm within less than substantial, that was also omitted. And Mrs. Justice Lang took the view that that tended to downplay the extent of the conservation concerns. So look at adequacy. That isn't an excuse for saying, well, just everything has to go in. But it's if there are things which might be missing, it's looking at the substance of those. That is what's not been mentioned of importance and ought to have been there. Again, relating to what's available, there's been a series of cases on access to application-related documents, either because they're background papers and so need to be made available when the committee report's available, or if they're made available, had to be made available earlier, for example, because the council's statement of community involvement gives rise to legitimate expectation that those will be published. So there have been a series of decisions. Last year we saw the Holborn Studios case, which was particularly concerned with the non-disclosure of documents relating to viability in an affordable housing case. The court saying, well, the government policy has changed general expectations that those will be made available. And in May, we had 3 judgments in the High Court in the space of 10 days on background papers, all of them planning cases. One of them was Kinsey. A particular complaint there was that the conservation officer advice hadn't been published, made available. Juden, which again also related to the conservation advice, but went slightly different way. And in Kinsey, the High Court had said, well, the advice should have been made available. In Juden, the High Court Judge, Sir Duncan Ouseley, took the view that the conservation officer's document was a first draft of part of the committee report, and so didn't need to be made available separately. There is an appeal on Juden on being brought by the developers, because the permission was quashed on other grounds. So we'll see whether that gets revisited. And then there's the decision of Robert J. As a High Court judge in Save Warshall, where again, background documents hadn't been published. So it's something that's being looked at quite often, and authorities are getting into difficulty on it. Okay, another source of, a rather more substantive source of litigation has been on heritage-related impacts and how those are assessed. We've had an awful lot of those cases, particularly since the Barnwell Manor judgment of the Court of Appeal in 2014, although that simply reinforced the existing case law. Series of judgments to look out for or read this year. Probably the most important one we've had so far this year has been Bramshill, where the rather complicated sort of country house redevelopment project, the Court of Appeal were looking at the question of to what extent benefits from the scheme can be used to reduce the level of harm when it then comes to applying the exercise in terms of determining harm and then doing a balance against benefits. And the Court of Appeal said there wasn't an obligation to use the heritage benefits to reduce heritage harm, although then left it very much for the, rather more for the decision maker than I think has been seen. Some of the earlier judgments have emphasised a rather rigid separation between the two. Bramshill suggested that it was, at least depending on the circumstances, rather more nuanced. There's a little bit of discussion of that issue subsequently in Juden, although Duncan Ouseley draws a distinction between some heritage benefits, which, like whether it's optimal viable use, which have to be put in the benefits category, can't be used to reduce harm, and then others that may potentially come into that. It's quite likely there will be some discussion of this in the Stonehenge judgment. There's challenge to the development consent order for a new tunnel at Stonehenge to replace the current A303 road through the World Heritage Site. That case was heard straight after the summer solstice, as it happens. Judgment is awaited on that, and certainly in the court there's a fair bit of discussion coming from, particularly from Mr. Justice Holgate, about how you deal with potential heritage benefits in determining what the level of harm is. So we'll have to see, but it may well be that the judgment will say some things about that. Moving on from heritage to nature conservation, a lot of habitats regulation cases have been coming through. Essentially, we know the sort of the substantial reach of the habitats regime in the light of cumulative assessments. So it's becoming quite a major factor, and something which is sometimes getting messed up in various ways. Two cases perhaps to mention, both which actually where the scheme sort of succeeded. One is Hudson, which probably ought to be better known as the Legoland case, where there had been a failure to have a habitats regulation assessment, and the High Court and then the Court of Appeal a couple of weeks ago took the view that that wouldn't have made a difference, and so didn't quash in those circumstances. And then Wyatt, which is a decision of Mr. Justice Jay about dealing with nitrates in the Solent. It's a major issue in Hampshire, but also affects some of the other areas of European sites. I mentioned environmental impact assessment only briefly because it's not actually been a major feature in, perhaps what might say is the conventional planning decisions. And whilst those of us with sort of reasonable memories will recall the very substantial amount of EIA litigation in the noughties, so the first decade of this century. I think since the decision of the European Court in Mellor, which required reasons to be given effectively for negative screening decisions, the effect of that in practice with reasoned screening decisions is that I think there have been far fewer EIA blunders or apparent blunders in conventional planning cases. So most of the EIA litigation at the moment concerns the sort of the fringes, issues quite a bit about offshore drilling, is coming into context of debates on permitted development rights and the like. So that is less an issue than it has been. Something coming up as an issue more is climate change. The courts have sort of been reluctant to sort of take the sort of the broad sweep of national or international elements into individual decision making. So the ultimate dismissal of the Heathrow National Planning Policy Statement challenge last autumn, the illustration of the courts saying that climate change had been dealt with sufficiently, and the cases so far where it's been said that oil exploration should be assessed in part because of the environmental consequences of using the oil which is being produced, as opposed to the climate change impacts of the search for the oil and the flaring and so on. But the actual consumption, the courts have so far not been prepared to take the view that those are matters which ought to be looked at in EIA for the development consent decision. So Finch and Surrey County Council is a recent case, but this is an issue which is coming not so much in the planning context, but in terms of offshore drilling. But we'll see something more of climate change as we go through the year, I think. Simon, those are sort of some of the issues which I think we tend to always look for.
That was such a superb, calm, clear summary in 10 minutes. Thank you so much, Richard. Hard act to follow, but Chris and I are going to do a bit of a twin act now, because we're both going to look at some practical issues to take into account. From my side, acting for either claimant or interested party, usually developer, and Chris will then be looking at it from the perspective of the defendant. And I come at it having always acted either for the claimant or the interested party, probably in an equal measure. And to my mind, in order to carry out the litigator's role in relation to judicial review effectively, it's very useful to experience both sides of the fence. I just wanted to focus on a few practical steps to bear in mind in relation to both very different roles. So first of all, looking at everything from the perspective of a potential claimant, whether that's an individual, a campaign group, or potentially a business with concerns as to what the authority or other public body has done. You know, number one point, it's a generalism, but my approach is don't store up potential points of challenge, however tempting it is to have them ready to reveal once the decision is taken. It's always better, surely, to persuade the authority to make the right decision rather than to fight a rearguard action through the court that at best results just in a redetermination. Secondly, the value, not just the requirement set out in the court's guidance as to the pre-action protocol to be followed and the potential consequences in terms of costs etc., for non-compliance. But to my mind, it is a very useful step for a potential claimant to take to provide a clear, well-argued pre-action protocol letter. And in my experience, they can be successful surprisingly often in resolving issues without the need for contested litigation. Clearly, when you're challenging a planning permission, it's too late for the authority to sort of concede they did wrong and for the position to be unrolled without then needing to issue proceedings with a draft consent order to be rubber stamped by the court. And that process alone can take quite a period of time at the moment. But it really is something to be targeting if you're a potential claimant. Also, to my mind, the value of pre-action protocol letters in terms of before the strict need to issue one arises, once the permission is issued, once you have the resolution to grant and you've got a gripe about that resolution to grant, to my mind, there's often value in making your complaints known to the authority and the fact that you will be pursuing things further if the alleged error finds its way into the planning permission itself. Of course, there's also the value of the PAP letter from the perspective of pre-action disclosure. Then just to identify an issue which arises, surprisingly often in my experience, which is, identifying the decision that you are actually challenging. And it's straightforward when you're dealing with the grant of planning permission, but often more complex when you're challenging the resolution of authority, where there's been a resolution of an authority to embark upon a particular process. And in relation to some processes, for example, the local plan process, or in relation to compulsory purchase, there may only be a narrow window for challenge of the resolution before challenges are precluded until the end of the formal process. So often quite a lot to consider, as well as the practical consideration as to whether there are routes to take to resolve matters aside from litigation, in addition perhaps to litigation. That may be before the permission is issued, seeking call-in of the application. It may be negotiations direct with the developer over mitigation that's needed in order to resolve the particular problem. The final 2 points I'd make from the perspective of the developer, first of all, who is best placed to bring the challenge, and associated with that, thinking about the costs position in relation to URHUS and what cost protection may be available, and being aware of the up-to-date requirements in relation to providing a schedule of your financial resources and those of and details of the financial support which you may be obtaining from others in relation to the proceedings, if you want to take advantage of protection against potential cost claim from the other side. And lastly, be aware of time limits. Obviously, that's the main thing that keeps me awake at night, but be aware of time limits. Looking at things from the perspective of a developer seeking to avoid challenge by a third party and the delay that can be caused, again, some bullet points. First of all, from the outset, obviously monitor carefully what objectors are saying and potentially legal concerns being raised, because you may be able to head them off at the pass. Secondly, obviously an important role that we have as lawyers acting for the developer is to carry out a legal review of the draft application, documentation, draft environmental statements, etc., to make sure that when the decision is taken, it isn't based on significantly misleading information, which may form a basis for challenge, and to make sure that the requirements of the EIA regulations and other statutory requirements are met. Thirdly, help the local authority where you can to make sure that their decision-making and processes are lawful and appropriate, but of course be aware of Freedom of Information Act requests that may be coming. So obviously any communications need to be visibly appropriate. Fourthly, the importance from an interested party's perspective of participating in proceedings, so that you can be liaising closely with the local authority to make sure that they don't prematurely consent to judgment or concede grounds unnecessarily, because the developer often has more skin in the game and possibly better resources than the local authority with a budget and other priorities. Two final points. Is there a quicker way through when you are faced with proceedings being brought if you're the interested party? Might a fresh application be the answer? Might a quick consent to judgment be the answer so that you have a redetermination? And lastly, of course, be aware that whilst participating in the proceedings and doing much of the heavy lifting, the interested party will not usually be able to recover its costs, save for a limited amount for acknowledging service and preparing grounds of resistance. So I hope all that wasn't too obvious, but sometimes it's useful to remind ourselves of the practicalities. And now over to the defendant, Todman.
Thanks, Simon. As Simon mentioned, I'll be covering it from the defendant's perspective, primarily drawing on my local government background. So really, and as with Simon, these are going to be some very practical tips, which may be obvious to some of those more experienced practitioners watching, but hopefully will be quite helpful for others. So the main theme that really runs through my short talk is get your legal team involved as early as possible in the decision making, ideally before the actual decision has been made. And then I'm going to be covering really sort of 3 stages of the JR process where there are sort of matters that can be picked up on, and having a really good legal team can really assist you as the defendant. So the first thing I wanted to look at was JR proofing your decision before it's actually been made. So there usually isn't a way to completely make yourself immune from being JR'd, but you can certainly mitigate or strengthen your chances of defence prior to a decision being made. While the stage of advice being sought will clearly vary depending on the type of decision being made, for the purpose of today, I'm going to be talking about officers' reports for a planning application, which is very useful given Richard's talk. And it's obviously often they're the basis for potential JR claims, but also for the defendant, often a potential final chance to pick up any JR risks before the decision is actually made. So here it's just worth pausing just to say, where you've got an application where there's lots of objections, there's expert reports being submitted, really detailed internal representations, odd QC opinion thrown in for good measure, these should all be seen as massive red flags for potential JR risk, and you should be involving your legal team in the actual drafting stage of the report prior to first publication. So because as many will know, addendums can obviously pick up matters later, but it's far cleaner if you can deal with these at the outset. And as per Simon's talk, the earlier the better, really. So while every report will be different, I've just listed out a few sort of usual suspects that I tend to look out for when I'm reviewing any officer's report. So the first thing I'll always look at is the recommendation. And it's amazing how often, even with very large schemes, how this cannot always be clear. So I'm talking about here things, is it subject to a section 106? Is the decision subject to a referral to the mayor or the Secretary of State? It's amazing how often these things are missed off. Secondly, conditions and section 106. So make sure that if there's reference to a condition in the report or a section 106 obligation, that these are listed out in the relevant list of conditions and section 106 heads of terms. Make sure they're consistent, and then also make sure that they obviously meet the lawful test of a planning condition, and in relation to obligations, regulation 122 compliant. Thirdly, and this is very relevant to some of the matters Richard was covering, objections and representations, both internal and external. Have these been properly addressed in the report? Have they been summarised? If experts' opinions have been submitted, have these been adequately addressed? Has, for example, the council gone out and sought their own independent report to deal with this? Obviously, this is a real hotbed for JR, so it's an area where you need to apply particular scrutiny when reviewing your report. Next, planning balance. So does the report include a section with a clear performance of planning balance? Does it reach a clear conclusion as to whether the proposal is in accordance with the plan as a whole? And then obviously, again, consistency with the rest of your report. Just finishing up on officers' reports, a few other common pitfalls that I often experience when reviewing officers' reports. Reference to statutory duties. Have the relevant ones been covered that need to be? So listed building, conservation area duties, public sector equality duties, and then if they have been referenced, have they actually been applied, which is obviously another potential JR hotbed. And then just to add to that, just ensuring that relevant policy documents have been referenced at all levels. So local plan, SPDs, a neighbourhood plan, MPPF, London plan, etc. If there is any emerging plans, making sure they're also referenced, and obviously attributing the correct weights depending on how far along in the adoption process they've made it along. As Simon picked up on, it's also common for applicants to have an opportunity to comment upon officer reports. And so if you're advising the applicant, this is obviously an opportunity to let the local planning authority know if you've spotted any potential JR risks that they haven't picked up on, to pick up on in addendums. With all that being said, those who regularly advise planning committees will know you can prepare the most perfect officer report, and then something completely left field will almost certainly come out of committee. My advice here really is only just to remain alive at committee of potential JR risks and don't be rushed into any decisions. There's lots of procedural matters obviously to be aware of at committee, new information, predetermination bias, but these could obviously be a seminar in their own right. So very briefly, the next couple of stages that the legal team could potentially get involved in is, so a pre-action protocol letter lands on your desk. So as Simon's mentioned, and also my experience, pre-action protocols stage is actually incredibly helpful. And in my own experience, I'd actually say probably less than, say, maybe even 50% actually proceed to full claim if you can prepare a really robust pre-action protocol response. Again, emphasize how important it is to get your legal team involved. It's also usually more than worth your money to get solicitors to instruct a good barrister at this stage to help prepare the pre-action protocol response letter. The benefit of this is you can formulate your case at an early stage, potentially knock the JR out before it gets any further, or at least make the claimant think twice before embarking on what could be a very costly challenge for them. And it also kind of picks up on one of the matters Catherine was talking about earlier, in that if you get a barrister involved in this stage, rather than you drafting the letter and then instructing a barrister at the claim stage and say, oh, I don't agree with this, that it cuts down on any potential inconsistencies later down the line. So the final scenario I was going to cover was when the claim has actually been received. And then from the defendant's side as well, even though minds will be turning to preparation of acknowledgement of service and grounds of resistance, the negotiations going on behind the scenes really don't stop there. And that's where the benefit of having a really good legal team instructed comes into its own, as there's regularly there'll be a possibility to be able to mitigate or settle the claim before it even reaches the courtroom. And so just as by way of a couple of examples, if as the defendant, you've prepared a very strong acknowledgement of service where your legal team thinks you have a very good case, high percentage chance of success, this might be an opportunity to offer the claimant a potential way out, with each party bearing their own cost or reduced cost, to give them a potential last way out, which they may well want to pursue, having read your acknowledgement of service. And this is particularly relevant in my experience to unrepresented resident claimants, as ultimately it could be quite bad PR for you as the public body defendant if a resident continues to fight and you haven't tried to at least give them a chance to back out, instead of having a very large cost bill. Another example is where the claim is incredibly finely balanced, and then here, as Simon alluded to, it may be possible to enter discussions with the interested party, see if any arrangement can be reached in respect of either potentially an indemnity in relation to part of the defendant's costs. It could be taking some of the burden of preparing quite difficult, expensive reports, and there's obviously lots of financial benefit in doing so, and the interested party may well want to negotiate, as often they will have more to lose, particularly if they're the applicant for a planning permission. And then my final point was on this was just to say that in addition to these sort of solicitor channels that I've been discussing, allowing barristers to open up respective channels with their counterparts for the claimant and interested parties also, in my experience, incredibly helpful. It can really help narrow grounds before being heard at court, or between the defendant and the interested party barristers, to ensure cases align. So obviously there's a multitude of other stages and tips that could be imparted, but I think I've probably run over my slot now, so I will wrap up there and just again, my message is instruct your legal team, instruct them early.
Superb, Chris. Good message. I wish I was Mr. Justice Holgate, because I would have controlled the timing a bit more fiercely on all of us, including myself. I should have said at the beginning, we're probably going to, I very much want to hear from Celina, given her role, having been on the Faulks Committee, which carried out its independent review of administrative law and has a really powerful perspective on the future of judicial review in the light of the government's proposals. And we have a few questions that we will be answering, which means that we will be going to 6:15. If people want to depart before then they can catch up on the recording later. But I hope people understand that it's probably best if we cover the material well. Celina.
Thank you very much, Simon. I will try to keep it brief, because as you rightly said, I was appointed onto the Faulks Committee about a year ago it was, and we started our daunting task in an array of concern and controversy from the outside world because of the terms of reference, and that controversy flowed, as we all know, from the Miller cases and the issue that was arising that we saw in the media about the judicial overreach, as it's commonly known, which I have to say, in very clear terms, the I do not and have never experienced that with the planning court or before that. I think the closest we got to that was when we were looking at the great Carla Holmes debate, and then subsequently with West Berkshire and the written ministerial statement, because of course Mr. Justice Holgate agreed with the claim that the policy was unlawful, but the Court of Appeal turned that round, which is an interesting reflection, I think, given who we have heading up the planning court. But secondly, again, the closest I think we've got to stepping into the political forum in the planning world is something like the recent, well, it's not so recent, the decision a year ago when Robert Jenrick accepted a consent order saying that the Westbury Printworks decision was tainted by apparent bias. So stepping back from all that, where did we go with the response to the call from the government? The biggest issues that we were asked to look at were justiciability and whether there was a way of codifying the judicial review process. But there were also debates to be had about ouster clauses. And that goes back, that is probably the closest to the issue with regard to the courts apparently taking statutory interpretation to a level that isn't stepping into what Parliament's there to do. The results of our deliberations were not controversial, but we did appreciate the response that came out, because there were a lot of concerns, as we all know, and the general consensus seemed to be that there had been a careful balancing of the concerns and an open acknowledgement of the context within which we were asked to look at things, but that the changes that we proposed were more practical than anything. We did mention the planning court and the changes that had come about as a consequence of that. But the conclusions we drew were that whilst it's very good for its particular purpose, which is the point, if you were going to try to apply some of its practices across the board, it would make the judicial review system less accessible to ordinary people. It's complicated enough. It's very easy, I think, for us as lawyers to forget quite how complicated it is. I mean, we see it as, who use it as streamlined. Yes, you can get caught up by some of the practices we have and rules we have to apply to. But if you do pare back the timescales, if you do require deadlines for things, and you are trying to run your own case without representation, it could end up in a great deal of injustice. So because we were looking clearly not just at planning, but many other issues within judicial review, and I know that Simon wished that we'd gone further with taking the planning court's example across the board, but it was clearly highlighted as a very good example of its function, but that those practices couldn't go further. So after the report was produced, well, it was submitted in earlier this year, but it got published at the same time as the government's response to it, which was an interesting way to take things. And it was a bit of a surprise to us anyway, that there were a number of things in it that had not, in the government's response, that had not come out of the IRA report, and that we had not actually specifically been asked to look at. In particular, the notion of a prospective quashing order as a possible remedy in judicial review, which is something that we just had never even contemplated as a sensible possibility. Certainly suspended quashing orders, which was taken forward in the government's response, was something that we considered could be dealt with through an amendment to Section 31 of the Senior Courts Act as a possible remedy, in particular because it had been used in varying forms as a matter of course. So we didn't see it as necessarily as controversial. It could be controversial, but the principle of somehow providing for a suspended ruling, or a ruling that suspends the next stage until something has happened and then you can actually have a final ruling, didn't seem to be, as I say, controversial. We will see whether that comes forward in a subsequent bill. But the other issue that the government raised was around concerns about statutory instruments, which again we had not highlighted or seen any concern about. The other matters that were raised by the government, one we simply, and many of us did actually respond openly, including Lord Faulks himself, was as a suggestion by the Lord Chancellor that there had been a finding that there was systematic, in effect, judicial overreach, and that simply wasn't the case. And we all said that, and I know that in the Bar Council's response, it was made very clear that there had been no such finding. Yes, there had been an increase since the 1970s in judicial review cases. Yes, there may have been instances recognised by some people of judicial overreach, so-called, but there was no serial example of that, and we were all concerned to make clear that that had not been the case. Beyond that, however, the suggestion of prospective quashing orders was raised, which again we had not. But the further point that was taken forward was coming back to whether ouster clauses should be something that is deployed across the board. Now, an ouster clause, we in the field apply regularly, which is the 6-week time cutoff. In other words, it is a clause that prevents an action being taken in absolute terms. The basis for preventing that action to be taken is the more controversial aspect of ouster, and in long-held cases, the courts have been unwilling simply to accept that there can be no exceptions. However, again, an effective ouster clause has been Section 289 and Section 288 6-week and 4-week time limits. That aside, there were a whole series of references to changes, procedural changes that could come through recommendations to the Civil Procedure Rules Committee. So those will not require legislation, and I agree, and they include removing promptitude as a requirement from judicial review. It just seemed to be an unnecessary element that might cause debate, and I think that's something that could sensibly come forward. There was some debate about the sort of pre-action stage. And I was listening very hard to what Catherine was saying, and indeed all of you, about how to make best use of the pre-action protocol itself, and indeed the pre-action protocol, which there isn't a protocol for, but certainly in terms of practice, it is a very effective way of just letting an authority know, and indeed letting a proposed claimant know whether there is going to be any case made and whether something can be done before it all requires going to court. Clearly, with the pre-action protocol, it's potentially too late because you have to go through the consent order, application consent order stage. But certainly, it has to be a sensible way forward and is the closest we have to any form of ADR. In terms of any other further changes, the government did raise concerns about whether or not time limits should be changed ordinarily. So in other JR forum, where the 3-month time limit is still there, and there doesn't seem to be much appetite to necessarily to change that. We cope with 6 weeks in the planning field for long held and very good reasons, and indeed the 4-week for enforcement cases. But again, my general feeling, and from what we can glean from the Queen's speech, is that I don't think that there's going to be anything wildly difficult that comes out of a judicial review bill. Language, however, that was used, was that there was going to be a bill that would restore the balance of power between the executive, the legislature, and courts, but nothing that after those words seemed to give any clarity as to what that could be. And I think it could, if it is correct, then that could potentially be the ouster clause position. But I just don't think that they're going to be brave enough to do that. But I'm very happy to hear opposing views, because assumptions need not necessarily be made. I think that's where I would going to leave things. We've got other bills that are coming up, the planning bill, and the environment bill is currently closing its debate at the moment. So we're going to be kept very busy looking at all kinds of judicial review issues in the planning field. So the main thing is to watch this space, I think.
That's fascinating. Thank you, Celina. Really useful to hear that sort of first-hand reaction to what's going on. Now, I did promise that we would spend a few minutes dealing with some questions, and so we'll deal with them fairly concisely, I suggest, in view of the time. There were 2 in the chat, and then a few in the Q&A. In the chat, Catherine, usefulness of disputed lists of issues. Is that?
Yeah, I mean, I think that's potentially a way of doing it. So this person, well, actually everyone can see the name, but we're told in Chambers because of GDPR not to say who asks questions. But anyway, where you effectively have the claimant's version of issues alongside the defendant's version of issues, so the court can just easily compare the two without the parties having to actually agree on a formulation. And I think that is probably what you do where you can't agree. But I think ideally what the court is envisaging, or at least what the Rules Committee was probably envisaging when they made the Chambers, when they made the changes, was a meaningful discussion between counsel, through which they would hopefully be able to articulate the disputed issues. I mean, just to take a really simple example, there might be an issue about whether the claim has been brought in time. I mean, it should be possible to have one sentence that summarises that as being one of the issues. But I suppose, as always, how long is a piece of string? It's going to depend on the nature of a particular claim and its complexity. In some cases, it should be entirely possible to have a single list of issues, and in others, I appreciate that may not be possible due to the nature of the claim or due to the personalities involved. So I agree that is definitely a helpful card to have up our sleeve. Thank you for to the person who asked that question.
And then very different area, the Dutch shell case, Richard, another stunning case following on from that agenda case. Sort of, do you read anything into that? You're on mute. You're still on mute.
Right. Okay. Start again. case where the Dutch courts held that Shell, who of course are headquartered there, had a duty of care to about 17,000 Dutch citizens who brought the proceedings with various environmental groups to reducing their greenhouse gas emissions. That, I think, is, in terms of the legal underpinning of that, is very much a relation of Dutch constitutional law, because English public law, of course, doesn't concern itself with duties of care to individuals, and tortious law and concepts of breach of statutory duty are sort of far more restricted within that. So I think the English courts will and have looked rather more at the expectations which climate change commitments put on government and organs of government, and then how that's then carried out and then affects how industry and business operates.
Yeah, thank you. Perhaps I can deal very quickly with two questions. One, do I really need a PAP letter if I've no ability to change a decision? Well, that's the age-old, frustration that often that we have. But rules is rules. Rules is rules is all I'd say. And sometimes it does unlock something. And then secondly, others may have views, but why doesn't PINS accept video recordings made, presumably of local authority planning committee meetings when you've got a point to make, someone who had to commission a written transcript? I don't know the legal or procedural answer, but I know that if I was an inspector, I'd want a transcript rather than to have to look at a video. But I don't know if you've had experience of that, Celina.
I've had experience of claimants being surprised in the High Court that they have to, if they're going to rely upon what was in the committee, they've got to actually watch you've actually got to watch it. And I remember there was about 3 of us on the other side, and when the barrister said, why on earth should I be watching this? We all went, well, we all did. So it is one of those things you couldn't. It's important. It's impossible to make submissions on it without actually having watched it, and to get a judge to take it into account. You're just going to have to produce the evidence.
Yeah. So finally, before we wrap up, there was a question about indirectly challenging the merits of decision by way of Wednesbury unreasonableness challenges. Richard, any comments on that?
Yes, I think the question was, given a lot of judicial reviews are against process, is there any way in which you can get the merits of the decision considered de novo, so considered afresh, if you challenge on Wednesbury unreasonableness grounds? I think, firstly, if a decision's quashed and has to go back, then it all has to be reconsidered. The previous analysis may be relevant, and if you want to look at that, look at Justine Thornton's judgment in Davison and Elmbridge, which is the latest word on that. I think if so, I think knocking it back does. I think maybe underlying the concern is that where a particular local authority decision is quashed, the reporting back of it by officers is sometimes done on a very narrow basis. Say, well, these were the legal criticisms, and these were process, these were technical, or what have you. Implication being that the rest of the council's analysis was all perfectly sound, and so you don't have to worry too much about having to sort of make the same decision again. Now, that ought not to happen in terms of how things are reported, and if there's a process error, the courts are of course concerned as to whether or not there might have been a different outcome as a result of that. So the process error would have at least a potential impact on the ultimate substantive decision. So it ought to reopen it. I think from a claimant's perspective, there are very few absolute killer points, which mean that a planning application decision in particular has to be remade in a different outcome. but quite often the more elements that lead to illegality, the greater the potential is for a different decision on a redetermination, or even a new application coming forward, there having been a rethink, which often actually is the best solution all round.
Thanks, Richard, and thanks so much to our panel. I think that you've all delivered great value to those watching. I hope those at home and in your offices agree, or if you're watching this later by way of recordings, do give feedback, do share the video when you receive it. And I do apologize that we did go over, but I think we had to present the rounded picture, and I think we did that. So thanks again and have a good evening. Bye, everyone.